Good evening and welcome. This is the law and you. A blessed Tuesday, and I hope you have had a blessed week since the last time we were together. Thank you very much for your feedback, your questions, and your comments on our social media handles. And we look forward to more interactions with you. The last time I promised you guys this month of October we'll be doing a series on employment issues. And today I'm joined by an amazing advocate of the High Court. But before I introduce you today, my guest, we had talked about issues, or if you have any topic that you'd wish to be discussed, you have any questions that you wish to be discussed, down on this screen you'll be seeing our email addresses. On YouTube, you can One Accord. On Facebook, One Accord TV, you'll be able to interact with us and we'll be able to answer or have that topic covered. I promised you the last time that I'll be having our guests today on this show for us to continue, learn, educate, and empower each other. My guest today is an advocate of the High Court. She has a master's in international trade policy and trade law from the Lund University in Sweden. She's also a partner with Mutugi Kithinji and Company Advocates. Just next to Safaricom House there, opposite there, you'll find our offices and we'll be able to interact with them more. Ladies and gentlemen, welcome, help me welcome Milkah Kithinji Kimani. Karibu sana.
Thank you very much, Ken.
Asante. The last time we were here, I promised people that we will be discussing on employment law. And before, maybe one thing I've not told the viewers is that with the ICC, ICJ, you are working with one of those, ICC, ICJ, ICTR in Arusha. Maybe you can have a comment on that and maybe tell people if my employer today decides to sack me or to terminate my services, can I take them to ICC?
Thank you very much, Ken. It's a great pleasure to be here today. I just want to first point out that we do not need to go to the ICJ, neither do we need to go to the ICC at all in order to have our employment matters articulated, because those are courts that are dealing, the ICJ is dealing with the International Court of Justice, it's the International Court of Justice that deals with international juridical issues. The International Criminal Court would be dealing with criminal matters, criminal offenses, war crimes. So when we're talking about employment matters, we would go to the Kenyan setup, which is the Employment and Labor Relations Court.
Okay.
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 So that the reference you're making to, that was criminal law work, and so it would not. That's not where you take your boss. You take them to the Employment and Labor Relations Court.
So what you're telling our viewers today, issues that deal with our matters, we deal them in the Kenyan courts. For ICC and the rest, that's another thing we have another time to discuss about.
Yes.
And thank you very much for the good work you did there. You helped a lot the people of Rwanda. So if you have a friend from Rwanda, this is one of the people who helped with those criminal justice process. Maybe coming to employment law, can you maybe have a comment when you're starting your employment? Are you starting on the issue of contracts, or should I just come one day, start working in your office? Should I walk in today in the morning and work? What is the best advice would you give an employer and an employee when you're starting an employment relationship?
So let's start with the employer, because the employer must be having a need, and they want to have that need met in the sense that there's a skill set that is needed. It could be a cleaner, it could be the receptionist, it could be an associate, it could be anyone, a messenger. And so that skill set there's a need that has been identified by the employer and he wants to fill it. So the most appropriate thing for him to do first would be to identify what would be the role of that employee. Because we find many people who have been employed in the sense, but don't have a job description. So I come in, when I came in, you told me I'd be the receptionist, but I clean, I am the messenger, I clean your car, I go to the market on your behalf. So exactly what is the job description of that client, of that employee? Secondly, depending on the nature or the urgency with which you need that employee, it would be more prudent to put it in writing. because you want them to understand what is the duration of that contract, what would be their pay, what is expected of them in terms, are they full-time employees or are you giving them a period of probation? What is it that when you articulate it that way, it's very easy for you to see the kind of obligations you'd be binding yourself as an employer, but also to get consent, written consent from the employee in signing and acknowledging that they have read the terms and understand them and agree with them.
So you're saying, I find employment contracts to be for those big jobs, eh? Maybe if I have maybe a house help or maybe a messenger that you're saying, or maybe someone to help here and there. Most people don't do contracts. What happens now if, for example, I've been employed and I don't have a contract? What happens when we go to court? Will the court say I don't have a contract, or how will I go about it?
So the court, the law actually takes cognizance. Employment Act looks at a contract, defines it that it could either be oral or in writing. So the fact that it is not written, we can presume it from the fact that it is there was an agreement, because you wouldn't be at your employer's residence or office or whatever it's
and he's paying you every month,
and he's paying every
or
month,
weekly,
because there has to be something that you have agreed, and on that basis then the court gives leeway for those kind of scenarios where we don't have anything in writing.
So what we are saying is that even if you don't have a contract in writing, you are still safe. And the biggest challenge I find from what you are saying is it will be on the employer now.
Yes, that is very true. So the employer will be taxed, will be obligated by the court to prove that there was no contract. How is it that this person who claims to be your employee was in your premises, he comes in 5 days a week, all your children know him, no one stops him at the gate, he knows where you bank, he has gone to a number of your suppliers. How is it then you can possibly claim that he's not your client, he's not your employee, because there's nothing in writing? So then the obligation now will be on the employer to show first that even if there was to show evidence that there was no oral contract. And that is a high task. That is an uphill task. So to avoid finding yourself there as an employer, it is more prudent for you to put things in writing. Please put things in writing, because then you are able to create parameters, boundaries a framework within which you want to engage the employee.
And then maybe as an employer, I'm seated, I'm like, I want to employ this person, and I'm not very sure if I'll be having him next week or next month or next year. So I'm fearing, I'm like, fanya kazi kwanza, tukiona vile inaenda nitakuandikia. What are the forms of can I write a contract for 1 day or maybe for 10 years, or should I nikikupatia nimeamua wewe you're my mfanyikazi forever and ever, or because I think that's the biggest challenge that people have.
So there are different types of contracts that come about. There's a casual laborer who walks in today kwa mjengo, he signs a paper, I walked in, this is my ID number, works the whole day, signs out, and on that basis he will be paid. On that day, Yes, because it's the same ID, it can be identified, the same person. So he'll receive his payment. You could actually do even a weekly contract. You could do a monthly contract. You could do a fixed term contract. You say 1 year or 6 months or 5 years from now. You could also have a permanent and pensionable, which that was the premise for most government jobs until the new change that was introduced by the government in terms of having contractual contracts. Now, in order to secure your interest, you don't have to give this person permanent and pensionable. But also you don't need to confine yourself to signing papers every day. Let me sign. It's that it should be, you should give yourself a leeway. So the law provides that you could have something called probation. Probation allows you to have the employee come in As you weigh them, you know, you're looking at their character, you're finding out, do they have integrity issues? Are they able to articulate, you know, when you send them somewhere, do they represent you or they go for their own interest? Are they faithful in terms of the money you're giving, keeping time, things like so. The period could be 3 months or 6 months. And once you issue that probation, if within 3 months you feel confident that this is a good employee, I'd love to retain them longer, then you can give them, you can confirm them and say, now from this date you're now my employee, and I'm now giving you can give them a longer term and say for the next 1 year you are employed with these terms. So you'd sign something different from what you signed in terms of the probation. What if you want more time to understand
them? Yeah.
Maybe they had a mishap. It was you know, you started employing them just when COVID was starting, so you didn't have that relationship. You were not able to work together. You were working offline, and you want to know them in person to see their demeanor. How do they act when they are faced with challenges? So you can extend it for one time. Now, what you need to know as employers, if you give somebody 3 months as a probation period, the next one extension can only be 3 months. You cannot do 6 months. No.
Okay.
You can only do 3 months, subject to what you started with. So if you gave 6 months, you can give an extension of another 6 months.
So we are telling employers who are fearing, you can still give a probation period of 3 months or 6 months, and check out this employee to be able to decide if you want this employee to be a permanent employee. And now this probation period, I think I like this. So I can give someone probation for 3 months, 6 months until Jesus comes.
No. I said you can only renew it once. After that, then you decide, are you keeping the person as an employee? Anything that is extra then becomes, it will be deemed, the court will deem that you wanted this person to be your employee. So they will be seen as your employee. So you have to be very careful about the timelines. Assuming the 6 months is done or the 1 year and you're tired, you're like, okay, I've tried to really extend grace. Maybe it was your
learning process.
You know, it's somebody's nephew or niece, and you're really trying to extend friendship, you know, to your friend and help this child, but they're not quite understanding the job, but you know, it's costing you time and money. So you feel, okay, to be honest, I think this is not your interest. I would advise you, you know, feel free to come for mentorship, but I don't think I want to extend the contract. So it's important then to terminate it. And on a probation basis, it would, you know, at the initials, at the onset when you're starting, you'd have already said, subject to your performance, you know, you'd have given the indicators that you would be weighing, so that it is not just a blanket or you know, an open-ended guesswork. It's that you're saying, these are our targets, this is what
these are your
do.
duties,
these are your duties, this is what we'll be weighing you against. Are you able to keep time? Are you able to draft?
So even me, at the end of the 3 months or 6 months, I know if I'm leaving or not.
Yes.
And now the question is, so if I give my employee a contract of 6 months, are you saying I'm stuck with this employee for 6 months?
No, you're not stuck with that employee for 6 months. So the employment law also takes into consideration that there are times when the employee can be errant, in the sense that they are indisciplined. So they could be wasting office resources. They could be using vulgar language. They could be coming when they are drunk. You know, just against the very, you know, they are actually demonstrating misconduct. Now, if any of those articles provided under section 47 can be proved, then all you need to do is to have a meeting with this employee who is still on probation and tell them, you know, on this day this happened, would you kindly explain yourself? The reason being that you don't want to summarily dismiss, well, there's a summarily dismissal, but which is available under that section. You know, you're saying, if I come drunk, I have come, you know, I'm swollen and things, you know, I need to explain myself. But because if it's known that that is my conduct, then I have every other right to, on the basis of misconduct, to lay you off. But assuming, let's give a different scenario. It's misconduct based on a situation where money got lost in the office, and the last person who had the keys to the safe is person X.
It's Ken.
It's Ken. So Ken, you're the one, you who is on probation, you were the last with the keys, and now the money is missing. And when we ask you, say you don't know what happened. You left the money in there, and so in terms of how the procedure should work, in terms of disciplinary, assuming your conduct has been very good before, and it's just this one incident. And even if it's not that one incident, I should give you an opportunity for fair hearing, in the sense that I call you, I tell you, Ken, now we'll have a meeting on this scheduled day. Please come with somebody who can, who you think you're comfortable with to come, to represent you, to just sit with you, and then now we can have a discussion so that we can hear exactly what happened.
I think you have introduced a very nice thing on the issue of termination and notices. And I want us to hold that thought a little bit. First, because we are still on the employment, I want us to kaya kwa ikazi kwanza. Then, so what we are saying is that for the employers, it's good for them to know if you have 3 months probation period or 6 months probation period, it helps you to gauge the employee and the employer. And it's also very important for them to have a contract, especially what you said, that when you go to court and maybe this employee comes and says you are paying me, I did not go for leave, and you don't have a contract or anything, the contract helps you as an employer more than even it helps the employee.
That's true. Very
now,
true.
maybe another thing maybe people would like to know. So when I'm employed, what are my benefits as an employee? For example, am I entitled to food, water, housing? Am I entitled to, unanipatia na jipanga, Kenya unasemanga jipange, pambana na hali yako, so am I pambaning with my hali yangu, how is it supposed? Then, can you decide today that I'm employing you and I'll give you 5,000 Kenya shillings? Or should I give you 1 million shillings? Should I give you 10,000? Is there something that guides the remuneration people need to get, or we leave it to the market forces?
Okay, so those are two questions you have asked me, Ken. So let's start with the benefits of the employee. First and foremost, and that is why we'd encourage now, so we are now back to the employee. It's important that you sign a contract. Sign that contract because it will enable you to know what are the benefits you will accrue from the job. So it's very clear. Are you able to get NSSF, NHIF? What caliber are you? Are you a casual worker? So that then it is a wage. Okay? Now, so let's go through the benefits. So one of the basic benefits that you should get, first is your pay, that you should be paid for the work that you're giving. Then second benefit is that there's a defined time as to when you should work. 8 a.m. to 5 p.m.
I cannot let my employees work. You know, kama kazi iko ijaisha, why are they going at home?
That is okay, but Ken, you also need to be human. You cannot just keep your clients, over time. I mean, past their working hours, because there are also labor rights that have to be protected. So the Employment Act provides that you should be, it should be an 8-hour. Normal working hours are 8 hours. So if you want to schedule it from 4 a.m. to assuming 4 to
12 or something,
yes, to 12
for one-ish,
that is one shift. That's up so long as it's 8 hours. Then the other benefit is that it also enables you to know that your basic government statutory fees are paid.
That's NHIF, NSSF. It's not a favor.
No, it's not a favor.
It's a must.
It is a requirement that every employee should pay that sum for their staff. Okay. Then we come down to your leave days. When should you have leave? Now, if you're working longer than 1 year, then you have 21 days.
So when you finish 21 days of service.
No. When you finish 12 months of service. 12
months of service, sorry,
yes.
You are guaranteed 21 leave days.
21 leave days, okay. Okay. Now, assuming you are on probation. So under probation, you have 1 week as your leave period. So the calculation is different because the issue is that you're not confirmed. There's a possibility that your contract would not be extended. So in that sense, then
And the 21 days, are they the same as the off days I go on Sundays or Saturdays or Monday or Tuesday? Or I can have my staff working for 7 days continuous?
So kindly repeat that question again.
The 21 leave days.
Yes.
If I give my employee 21 leave days, am I entitled also? I give him off day every week or something. Or I can have my employee work continuously for 7 days.
No.
Yeah.
There is the law recognizes that you can work 6 days out of 7. So ideally,
so every week niko
there's
na
a
off day moja.
Yeah.
Asante.
So
now, if I have a house girl in my house, and I decide for her to work continuously, I'm on the wrong. That's what we are saying.
Yes.
So there's the off day every week once. There's the 21 days after I finish the 12 months or 1 year.
Yeah.
Then there's the maternity. If I go for maternity for 3 months, hiyo 21 days itahesabiwa ama bado itakuwa?
No, it will be available.
So I'll have my maternity and I will still have my 21 days.
Yes.
Wow. And I still have my 2 weeks on paternity leave. Asante. Then.
Oh, but you see, for the employer, honestly, let's think about the employer.
Yeah.
You see, and that's why. Okay, I feel the employer to an extent. You see, if you have employees who are all, everyone is giving. I'm a lady, I understand.
You have 5 ladies.
I have 5 ladies in the office, and so in June, Mary goes on maternity leave. So I'm counting 3 months.
September.
Okay.
Jane.
September, as you know, Mary was coming in. Then Jane is going. I mean, it can weigh an employer.
But that's a law. Sheria ni msumeno inakata mbele na nyuma. Then maybe because I see our time is, I thought we had time, my viewers, but I think we are here again next week at time like this every Tuesday from 8 p.m. every day. But as we finish up on that, the issue of leave days, if I'm sick, bado nitahesabiwa ulienda maternity, huwezi enda ukuwa mgonjwa. Ama nitahesabiwa you have the 21 days or you have the one off a week, and also as you close up on the other one.
Okay.
Yeah.
So if the law also provides for sick leave. So assume you got COVID, God forbid, and you are incapacitated, you should be able to get leave. For the first month, the office should pay you full pay. I think it's the first 2 months. And then the next month you'd be on half pay, assuming you're very sick. So you'd be on half pay. So there are organizations that would get to a point and tell you, okay, now maybe it's now 8 months and you're still unwell and not able to come. So they could offer to give you a lump sum or package. For purposes of just, their goodwill. Cushioning you even as you recuperate, and so that they can put somebody else in your place, and but it should not be immediate. The issue is that it shouldn't be immediate, that I fell sick today
on Monday
and tomorrow by Thursday you didn't have a job.
You have been told, want to give you a package.
Yes, want to give you a package. No, it's that you take it systematically. The 2 months full pay, then the next 1 month half pay. Then you can always get into discussions and see how best.
But that one is for someone who has worked for a long time, because the law provides also, if you work for 2 months, you are guaranteed 7 days for full pay, 7 days without pay.
True.
But also if your employer is a good employer, he can give you more time. We just have 30 seconds. I don't know if
I want to say
you have
something about
else.
the minimum wage.
Yes, minimum wage. Yes, that's that question.
There's a minimum wage that is provided for by the Employment Act. It's a side subsidiary legislation that determines how drivers, house helps, shamba boys, everyone. So let me tell you, as employers, as you employ these people, please understand there's a minimum wage. It caters for their housing. That's another benefit. So that if you're not paying for their house, you're supposed to give them that money into their pay, and it's already calculated. And it's important that we are aware that these are obligations that are put on us as employers, and also employees. It's important to know that that is the kind of money you should earn. So the earlier you get to know this, the better.
And for the minimum wage, so for example, minimum wages are average of 10, 12,000 plus minus, driver 17,000. This one, I think in the next show, maybe one of these days we'll be able to give the different pricings for, because it has to be gazetted every now and then. If my minimum wage is supposed to be 10,000 and you have been paying me as a house girl 5,000, and maybe after 3 years I take you to court, what I'm getting you to understand is that the court will calculate the balance, the difference that you are supposed to pay me, times the 10 years you have not paid me, and you get it as a lump sum.
True.
Ladies and gentlemen, I hope it was informative, educative, and empowering. Our time is not on our side, but next week on Tuesday, we'll be continuing the series on employment matters. And this time, we have talked about the workplace, but now we want to know, when you are not happy with your employer, when you're not happy with your employee, what happens? We'll talk about termination, we'll talk about redundancy law. Because I know a lot of people, especially this time for COVID, companies would come and say, the company is not doing well, we want to lay you off. What's the procedure? Do you have something that you can work around? Is the employer, does he have permission to deduct your salary? If you had employed me with 20,000 and today is 10,000, join us next Tuesday, One Accord TV, on our social media pages and even on YouTube. As you join, our panelist today was Milkah. Thank you very much, Wakili. Milkah Kithinji, advocate. God bless you. See you next Tuesday.
Thank you very much, Ken.
Asante sana.
Great pleasure.